Good afternoon, honorable judges, distinguished authorities of the CCP and others, esteemed delegates for this symposium. It is a great honor for me to be here today. My name is Sergio Muro. I am a financial sector specialist working in the Insolvency and Debt Resolution Global Team of the World Bank, based in Washington, D.C. I am very happy to be in Pakistan yet again. This is a country that I have learned to enjoy very much in my previous three visits to the country. The topic of the presentation for today I was asked to discuss was about the importance of insolvency systems in particular. And this is a topic that is very dear to our heart at the World Bank. The World Bank, together with the United Nations Commission for International Trade Law, are the co-standard setters, designated as co-standard setters in this area, both with the World Bank principles on effective insolvency and creditor-debtor regimes, and the insolvency law guide by UNCITRAL. So this is a topic that is, as I was mentioning, is very dear to my heart, and I'm very, very happy to see that some of the previous speakers, also the chief judge, was delving into this topic, which I think it's very important for us to consider in the larger context that was mentioned before, but also with an even broader perspective of how this particular issue can have an important impact when we are thinking about inclusive development. So let me start by considering some of these specific areas of importance. And one of the things that I want to start with is with the idea of why we put a special emphasis on the insolvency systems. And so when we look at typical commercial disputes, when you look at typical civil disputes, they are inherently different from insolvency ones, right? We have typically, in most of other disputes, one litigant against another. In the insolvency area, we have a multi-party system, which is all acting together. And at the same time, when we think about insolvency cases in particular, they feel different than other type of disputes. In most type of commercial disputes, there's a backward-looking focus. There has been something that has generated the dispute, and that is the thing that needs to be solved. When we look at insolvency cases in particular, well, it's not only that backwards-looking aspect that we need to focus on, but also the forward-looking aspects. Because in many cases, we want to think about what's going to happen to this firm that has run into distress, what's going to happen to the customers of that firm, what's going to happen to the suppliers of that firm, what's going to happen to the employees of that firm. So in a sense, the insolvency system itself works as an aggregator, right? And so the impact that it may have, it can be larger than what we think in other type of disputes. And connecting these ideas that I was mentioning to some of the idea of inclusive development, when we want to promote inclusive development, we know that we need to have access to credit. And for access to credit to occur, any person who's going to be investing, of course, is going to need to have some sort of an idea of what's going to happen if things go wrong. And bankruptcy is what happens when things go wrong. So having a transparent and an effective and affordable system for insolvency is of deep importance here. And this can be seen in many different aspects, but the graph that you see there takes a look at the recovery rate in different countries, the recovery rate within insolvency systems, and the access or the percentage of private credit of credit to the private sector as a percentage of GDP in each of the countries. And you clearly see that positive relationship between both of them, right? So when this aggregating system, which is the insolvency system, works well, then it facilitates that access flows into the economy. In addition to that, the insolvency system, we don't typically talk about the insolvency law per se, or a specific procedure, as was mentioned before, with the emphasis of the winding up. We think about this system because for these mechanisms to work well, there needs to be a suite of different procedures, of different tools that are available to debtors and creditors so that they can use it and benefit in the resolution of the situations of distress. And this needs to include many important mechanisms. For instance, the identification and the early warnings, early warning tools that allow you to know that some firms may need to use this system, and also the provision of tools to address restructuring before the firms are actually insolvent, right? And so when, as the Chief Justice was mentioning before, when these systems work well and we can generate restructurings, we get the opportunity to rescue the business, and in so doing, preserve jobs, provide creditors with greater returns, produce returns sometimes for the owners of the company themselves, and also for the whole economy of the country to reap the fruits of that rehabilitated company. And here, what we see in the graph is another measure of trying to capture this type of ideas. When the laws within the country itself, what we have in the horizontal axis as the strengths of formal reorganization tend to be stronger going to the right, what we have is a higher recovery rate for the creditors involved in this type of procedures. But the other point that is very, very important is that even though we are focusing and we try to put a lot of emphasis on this restructuring of firms that are in distress, we want to make sure that we are looking at the viability of those firms and make sure that only those viable firms are the ones that are being restructured. Because if we follow that same concept and we try to restructure firms that are not viable, then we end up with other type of problems where we concentrate assets, where we concentrate resources on the economy in inefficient firms. And this is what is called the idea of the zombie firms. These firms that, again, have very low or negative productivity and capture the assets of the economy and don't let them go into more productive uses, generating more wealth that can be enjoyed by the country. So for these other situations, we want to have a quick, efficient, affordable, with an easy access to liquidation mechanism. And we know specifically from several empirical studies, and I was happy to hear some empirical studies done here in the country too, that where the insolvency system works worse, the incentives for the users to, again, make use of that system diminishes, and this generates that the share of assets that are stuck in these so-called zombie firms grows. So more of the resources are stuck in unproductive uses and are not reallocated to better ones, generating, again, more problems for the economy. And of course, for doing all this, and this is a setting where we have regulators and we have judges, we need a strong institutional setting, right? The experience of reforms around this area is an experience of a lot of challenges. Making these systems work is very, very challenging. And so for that reason, it's very important to make sure that the institutional setting is solid enough and robust enough to support that system. And that it includes elements, as we heard before, on ADR specific to the insolvency system itself, right? We want to have the possibility to develop out-of-court workouts and systems that are going to be easing the burden on the courts so that they can apply themselves to those hard cases that are going to come their way anyway. And finally, a very, very important point here is the point about discharge mechanisms. So when we think about this cycle, we think about these firms or these businesses starting, in many cases doing quite well for some time, and then going into downward sloping trajectory, and maybe sometimes they need to exit the economy. But that doesn't mean that the entrepreneurs, the people who were working there, perhaps were not valuable. Maybe that's just the business idea is not working anymore, but we need to have that same strength re-enter the market and provide new force into the economy. And so the insolvency system itself needs to focus on that discharge and the creation of a culture of fresh start. As I was mentioning, developing this insolvency system is a very difficult task. We know from international experience that this is something that requires a lot of efforts, and many times the first initial effort is insufficient to reach the results that are intended. And perhaps for this reason, we see continuous efforts around the world in order to improve this system. And so we have recent developments in the region, for instance, the new insolvency and bankruptcy code in India, or the new bankruptcy law in Saudi, or the new bankruptcy law in Jordan. We could say the same of Egypt or Bahrain, for instance. The new completely redeveloped insolvency law in Greece, the preventive restructuring procedure specific that has been done in the Netherlands, the new European directive on preventive restructuring, and proposals that keep coming, like for instance, the ones that is being worked on in Bangladesh right now, or the one that is being worked on the UAE right now. So this is a process that takes a lot of time, but thinking about time and thinking that I have a very limited amount, let me just briefly conclude with some ideas of what can be done and what has been done through some of these changes. And let me just focus on a couple of examples. For instance, the case of Brazil, where through the introduction of the reform in 2005, the introduction of prepackaged reorganization procedures, they were able to contribute to a significant increase in long-term lending in the country, going from 23 to 74% of domestic credit to the private sector as a percentage of the GDP. And similarly, when we look at the reforms that were done in the corporate reorganization code in Colombia, we see a significant reduction in the amount of time that cases were taken, from 34 months to 12 months. An issue, again, the duration of cases, that is an issue all over the world, but it's an issue that needs to be tackled. And so efforts on strengthening the insolvency system, efforts on strengthening the institutional setting and providing tools to everyone to do this can generate these results. So I want to thank everyone again for giving me the opportunity to talk to you here about this important topic, and I congratulate everyone for the fantastic symposium that you are having here. Thank you.